right, this is cause number 1830854, and sir, you're Juan Sanchez?
Yes.
And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So but we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests, and then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that, Mr. Nichols let me know that, then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results, testing, money owed, all of those types of things I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the...
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on an arrest out of county. And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing. I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand. And again, I don't think he's not entitled to have all that stuff. So
sure.
I kind of agree with I don't want to subpoena directly to those agencies was the proper way to do this. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May. I don't have anything really responsive to that at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Let me look at the motion itself. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations, and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Your Honor, my client is wanting to stay on probation, and the court may take into consideration his performance while on probation, including his payments, his report, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay. Sometimes you get more with honey than otherwise, so make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence, and so that's not the way we're going to do it.
The ducis tecum was set for the day that it was initially set for a hearing, and it did specify that date for the hearing, I believe. We ended up moving the hearing date because of conflict.
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together to turn over.
I mean, yeah.
There was something that the court was ordering her not to turn over.
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. Wong, or do you have any concerns you want to
If there's,
make the court aware of?
Your Honor, just with the clarification of our departmental chronologicals, which include anything that pertains to the case that happens, chrono telephone calls, auto-generated appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena, as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify, as to those items specifically being released that were not listed, with the exception of the offense report.
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronologicals.
well, and these aren't, the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, but I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out, though, I think whatever Mr. Nichols, y'all get together, obviously offense report, if y'all have the offense report and you don't even have it, then you need to get, I mean, that's great. Everybody can get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I guess
Not-
notes may be work product, but I'm not real.
that's what I'm thinking about, but it's
Not
not
too
really
concerned.
attorney's notes, and so I don't know that that would
I
be an
would object to
issue.
that, Your Honor, on the grounds that it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
That's it, and that's what I just said. You seem very frustrated, and I'm not sure why. I don't know.
Right here, the judge is basically saying, nice try, but that's not how subpoenas work. The defense went for a shortcut, and the court is calling it out gently, but firmly. Anytime a judge starts explaining procedure like this, it means someone pushed the wrong legal button.
That is alarming to me that we would have to even compel anything under 3914.
This is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And the last thing you want to do is talk over me.
Yes, Your Honor.
So I'm sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do, because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not gonna have probation start turning it over to individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your, any type of documentation, whether it's at a hearing or a plea or a trial, of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols, Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in what, a couple weeks or so? Fine with that?
That should be fine, Judge. We'll be able to get everything scanned in and provided through the portal.
Perfect, thank you. All right, y'all are all excused.
You needed?
I'm sorry? No, ma'am, if you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're going to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations, then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena, then you can get a subpoena. If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay? Good?
Yes, Your Honor.
All right, thank you, y'all.
Thank you.
All right, this is cause number 241916, and are you Edward Miller? Good morning. And so Mr. Miller was evaluated by Dr. Hamza for competency to stand trial. I received that report dated June 26th of 2025. The finding in that report is that Mr. Miller is not competent to stand trial. Is there any other evidence with regard to competency? Ms. Holmes?
No, Judge.
And then at this time, I am going to find that Mr. Miller is not competent to stand trial, that inpatient treatment is required for competency restoration. Order you to the appropriate facility. This is just to get you some help, Mr. Miller, okay? And we're going to get you some help, and then we're going to get you back in here. And it'll be for a period of not to exceed 120 days from the date that he gets to the appropriate facility. All right, you can go back with the bailiff. Good morning, ma'am. You're Reagan Howard?
Yes, ma'am.
Ms. Howard, would you please raise your right hand? Best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. Let me get this. And she's just going to plead to the motion.
Yes, ma'am. Yes, Your Honor, and I get it updated to the side, and Mr. Smith, there may be evidence he wants to put on it here.
Okay. All right, let me get this put up. Ms. Howard, in cause number 2239924, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2024 for the third-degree felony offense of deadly conduct discharging a firearm, and that was a 6-year deferred probation. Is that correct?
Yes, ma'am.
And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department October 7th and November 1st of 2024. And is that true or not true?
Can you repeat that? I'm sorry.
The dates were October 7th and November 1st of last year, 2024, that you did not report. Is that true?
That's true.
Okay. Count 2 alleges that you're behind in your court-assessed fees. And is that true or not true?
That's true.
Count 3 alleges that you also failed to report June 27th, August 21st, and September 24th of 2024 to the probation department. Is that true or not true?
That's true.
Count
Notice this tug of war the defense wants the whole probation file. The state says it's overkill, classic battle relevance versus fishing expedition. In court, the how matters as much as the what.
4 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
That's true.
Count 5 alleges that you failed to immediately report your contact information as ordered to the probation department. Is that true or not true?
That's true.
Count 6 alleges you provided a urine sample August 27th of 2024 that tested positive for alcohol. Is that true or not true?
True.
Count 7.
Tied to the same UAPH.
So count 7 alleges that on that same date of August 27th of 2024, you also tested positive for cocaine. Is that true or not true?
That's true.
And then count 8 alleges on that same date, you also tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 9 alleges that you did not provide verification of performing the community services required. Is that true or not true?
True.
Count 10 alleges that you did not provide verification of entering and successfully completing the anger management program. Is that true or not true?
Not true.
Not true. I didn't get assigned to anger management.
Okay. Count 11 says that you did not submit to alcohol or drug screening September 9th and September 16th as And then apparently you had possessed a device or an object for the purposes of providing a fake specimen. Is that true or not true?
Not sure.
Count 12 alleges, again, that you're behind in your court-assessed fees. This was done a little bit later, so the amount is more. Is that true or not true?
True.
And then count 13 alleges that you didn't provide verification of entering and successfully completing the moral recognition therapy, the MRT program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 9 and then 12 and 13 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to those counts freely and voluntarily, find them true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing, and we'll get an updated pre-sentence report done, and if at that time the state wishes to put any evidence on with regard to counts 10 and 11, they can do so. And then anything that you think is important for me to know at that time, get that information to Mr. Kemmler. He'll present it to me on your behalf when we come back. And this is unagreed.
Correct,
Jody.
Your Honor, there's nothing.
Okay, all right.
Your Honor, we had asked for a bond. I think if the court would set a reasonable bond for Ms. Howard, and she were able to post that bond, she would be able to demonstrate to the court.
That's denied. I'm going to find at this time it is in the best interest of our community and under the Article 1517 that even though this is a deferred probation, based on the nature of the underlying offense, which is a deadly conduct discharging a firearm, the fact that it looks like Ms. Howard has done pretty much nothing, including not reporting while she's on probation, and when she did test positive, that it is not safe at this point until I have more information for her to be out. So that's denied.
You did have her support letter.
Yes, and I've already received those, and we'll get those to probation as well so that they can be part of that pre-sentence report. Okay, you can go back with the, what's that?
So is ISF off the table?
Well, I don't know right now until we come back for sentencing. So probation will come talk to you, talk to Mr. Kemmler. I'll get all the information about what's been going on, and then I'll make a decision when you come back about whether I keep you on probation, revoke your probation, keep you on probation, send you somewhere for treatment. It just depends on the information I get when we come back, okay?
And I'll be out to see you.
Okay, you can go back with the bailiff. Good morning, you're Von Zell Hall? And in 24-1747, Mr. Hall is charged with murder, and what is the announcement?
Your Honor, at the last setting, I requested some digital media. Since then, Mr. Nichols has done an impressive job of providing most everything I need. Unfortunately, I think some of it hasn't been provided to him. And I've discussed this with him. I'm trying to get a few more items I think are pretty important to this situation before we announce. If I could have a 30-day reset.
There was some follow-up testing and some documentation that he was asking that I don't see in my file, so we need to find out if it exists, where it is, and things like that, so.
All right, so I'll do one more reset. Y'all can work on that. If there's anything that you can get, obviously get that to Mr. Matuska, and Mr. Hall, Mr. Matuska will be out there, I'm sure, to visit with you once he gets everything to see what y'all want to do at the next court date, okay? All right, you can go back with the bailiff. Thank you. Good morning. You're Anthony Williams? Correct. And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
What's your signature? Mr. Williams, in cause number 240401, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from December 7th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Whoa, freeze this moment. The judge is done with the attorney's attitude. When a judge warns you about arguing even when they're agreeing with you, that's a sign your tone just cost you points. Courtroom rule, protect your client first, ego last.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? No. And do you fully understand them? No. And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 7 years. There's a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Sorry. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can get a pre-sentence report done. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today so they can start that report, and she's sitting at that desk right over there. All right, we'll see you back at sentencing.
Yes, ma'am. Thank you.
Yes, sir. Good morning. Are you Ashley Faye? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Faye, in cause number 250355, you are charged with the state jail felony offense of credit or debit card abuse from October 16th of 2024. Your indictment alleges that you were previously convicted of theft, a state jail felony, March 15th of 2019, in 3 different state jail felony cases of theft on that same date. And how do you plead to the charge? And are those prior theft convictions true? Answer out loud, please. Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
This is the judge hitting reset on chaos. She's creating a clean paper trail probation prosecutor defense. That way nobody can later claim we never got the file smooth controlled and very intentional.
Do you not understand something?
No, I kind of wanted to ask for probation.
So this isn't where you do that. Y'all have negotiated with Mr. Rojas. Mr. Rojas negotiates with Mr. Hoffpower. They do all of that. I don't get involved in that process. So there's a couple of things you can do. You can, go ahead, Mr. Rojas.
So we did have an offer for a cab judge. We talked about that, and this is the one that she chose. If you have any second thoughts, we can talk about that some more.
Do you want to go talk to Mr. Rojas about that cap? The cap would be pleading open to me, where I could give you time in prison, I could give you probation. It would depend on all the information that I was given at a later hearing for a sentencing hearing. If you want to do that, then
Yes.
you do want to do that. I think you're going to have to do the unagreed, the different.
Right, that's different paperwork.
No, you're not. With everybody's permission, I can make those changes on this.
Which one? Okay.
Yes, ma'am.
What is it, cap of what?
Cap of 5.
How do I? No, it's not. It's writing with it. So I'm just scribbling on it. So on the agreed punishment recommendation page, I am marking off the cap of 5, and then I think that's really the only thing that needs to be changed. Okay, so then let's go back. The agreement that you've reached is for a cap of 5 years. And I want to make sure you understand, it sounds like you've gone over it with Mr. Rojas, that what that means is that you're leaving your punishment up to me. As long as I give you 5 years or less, I can consider probation, you cannot appeal. Do you understand? And you have an absolute right to have a jury come in and determine if you're guilty or not. You can leave your punishment up to a jury. If we go forward this way, you're waiving that right. And is that what you want to do?
New case, new energy. This shift to a competency ruling shows how different courtroom rhythms can be. This isn't about guilt. It's about whether the defendant even understands what's happening, a totally different legal universe.
Right. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Fay is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty and true freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a report that'll give me more information about you, your history, your cases, and then we'll come back for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas and he will present it to me on your behalf when we come back. All right, and go back with the bailiff. Yes, ma'am.
This is a brutal moment for Reagan Howard. She admits nearly every violation, and honesty can help, but with a firearm case and repeated non-compliance, the judge is clearly leaning towards safety over sympathy. Would you have admitted everything or fought it piece by piece?